Do I need a probate bond to get authority to sell a deceased parent's house during the estate process? Often, yes. In many estate cases, the court will require the personal representative, meaning the executor named in a will or the administrator appointed when there is no will, to have a probate bond in place before the court issues the official letters that give you authority to act for the estate. Without those letters, you usually cannot sign a listing agreement, a contract, or closing documents on behalf of the estate. A bond is basically a financial guarantee meant to protect the estate and the people who inherit if the personal representative mishandles estate money. Sometimes a bond can be avoided, for example, if the will names a qualified resident executor and the will does not require a bond, or if all adult heirs or beneficiaries sign a bond waiver in situations where a waiver is allowed. But even if the bond is waived at the beginning, a bond can still be required later, or the amount can be increased, especially if the house is sold under a court order and the personal representative will receive the sale proceeds into the estate account. One practical tip: if you use a surety company, the bond filed with the court is different from the surety's indemnity agreement. The personal representative usually signs the bond as the principal, and the surety signs as the surety. But an indemnity signature can create personal repayment responsibility if the surety ever has to pay a claim. The safest approach is to ask early whether a bond will be required, and whether it might need to increase once sale proceeds come in, so your closing is not delayed.